Now, Ernie, you gave me the statement, a bad lease is worse than a bad tenant. I'll say that.
You find it funny because I read leases all the time, and I look back to when I was in college. I never read my lease. I had no idea what it said, not really, and most people are that way. We don't read our agreement when we sign up for our cell phones. We don't read our agreements when we download new software. We're just click, 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 and we're ready to go. And most people treat their leases that way, including landlords. You don't know the power you have because you haven't studied the power you have. And if your power is lacking, it's probably because you've got a bad lease.
So I got a few questions here. What are we looking for, getting back to in good behaving tenants that also pay their rent on time?
Mm-hmm.
I know that we've been guilty of this, of cutting someone some slack on the payment, and the payment only. Otherwise, they're a great renter, but then that always comes back to bite us, it seems. And you had a lot to say last week in your short tip of the month that you gave us at
Right.
the RIA meeting. But what can you tell us today?
Well, it comes down to the expectation that you set as a landlord for your tenant. If you set an appropriate expectation for timely rent payment, then your tenant will likely rise to that expectation. And if they don't, you can use that same lease and its provisions to transition away from that tenant, mostly through the eviction process. But you have to be willing to do both. You have to be willing to utilize your lease in a way to set a very clear expectation. It's not, well, whenever you can pay me, that's fine. Well, the lease says something more precise. And then when that tenant simply cannot meet that standard, you have to make an executive decision to protect your business, to protect your asset, and begin enforcing the terms of that lease so that you are protected and that you separate yourself from a tenant who, even after proper screening, now presently cannot sustain their rent obligation. You have to be willing to pull that trigger and be willing to do it early as opposed to late.
So, if you sign a lease with someone, and this is a general attorney type question, can't I get in trouble with one of my tenants if I choose not to follow the written agreement and make an allowance for this, because then that could put in jeopardy some other things? Or how does that work as far as, you have an agreement, you really have to follow that agreement. And if you don't, you really need to amend the lease to say where you're not following it, because you can then give up some other legal ground that you might need to fall back on. Can you give us an example of that?
Sure. Now, most leases, many leases, in fact, the best leases have what's called a non-waiver clause, which in its most basic form says, just because I didn't exercise my rights earlier on in the lease term doesn't mean I can't later exercise those rights. Now, that's what it says in black and white, and that's a great term to have. However, there are some courts who won't honor that. There are some courts where if you say at the end of a lease, well, now I want to enforce X, Y, and Z, but the judge, especially in the justice court, which are courts of equity, they're out to determine fairness. That judge may say, I'm not going to let you enforce this because your course of performance has been to let it slide and let it slide and let it slide. And now you're coming to me to enforce a term that you let slide for 2 years. Sorry, landlord, it ain't happening. And so I've seen courts disregard non-waiver because your performance was to waive. Things went sideways, and now you decide, well, this is the way I'm going to enforce my lease. And the judge says no.
Right. So I kind of think of, I heard this in church about, tell them what you're going to tell them, and then tell them what you told them.
Right. And if you're consistent from beginning to end, you're going to have a much better relationship because, as I stated, you set an expectation, they will likely rise to that expectation. If you set none, then they're going to meet you right there at no expectations, and they're going to run it as they see fit. But as a good landlord, you want to establish a benchmark for what's acceptable and what's not, and then stick to it as well. Show the tenant that you value your lease and its terms, as much as they do. And you're going to have a much better experience if you hold them to the terms of that lease.
Well, and I guess communication is key, and getting back to if you have a mooring of knowing what's in your lease, and you don't have to like master the whole thing. It's just the key points, and again, I mean, we're encouraging you to join a RIA if you're a landlord, and come to our landlord group meeting, and that's where. And in community, there are people that you can pick up and call, and they've been through those experiences. And the biggest value in those experiences, and you've seen this very well, is that if you study your colleague who is suffering,
right,
then you can basically take on that suffering with them in a way and experience that, and then purpose never to be in those shoes again. And so you're going to go back and read your lease, and you can avoid a lot of pain. So join your RIA. So you've mentioned elements of the lease, and we kind of touched on that about certain things that are in certain leases. So I got like two questions here on elements. What elements of the lease are must-haves? They got to be in there.
Right. So there's a few. I'm going to touch on a few here. The first is an application of funds clause. And what this clause allows you to do is to take in any payment and apply it first to any fees that are outstanding. Generally, this is for late fees. So you might be in the middle of March and you finally get payment. And so late fees are due. Maybe there's a broken window and your lease requires that for the negligence of the tenant, they're required for those to cover the cost for those repairs. And maybe there's some other matter. But on their check, they note in the memo section, rent only, no fees, I'm serious. And you go and deposit that check. Are you bound by the note in that memo? Not if you have an application of funds clause. Generally, the memo is virtually meaningless in this kind of transaction. But that application of funds clause allows you to take the money that you receive, which your tenant has designated as rent only, but who has agreed in your lease that you can apply that money first to unpaid fees and other charges that are owed to you by virtue of that lease, leaving a rent balance. At that point, what I would suggest is sending a notice of default and say, you still owe X amount in rent, to which they'll reply, no, I paid my rent. In fact, I ordered you in my check to apply it exclusively to rent. You'll point to the application of funds clause and say, you ordered first that I could do whatever, apply these funds in whatever way I saw fit, and I applied them to fees first. Please pay the rest of your rent balance. And by the way, here's a notice to vacate for non-payment of rent. And so again, you establish the expectation based on what's written in your lease that whenever payments are made, you can apply them in a business manner that makes sense for your business. Applying it to rent exclusively and perhaps waiving these other fees, not a good business decision.
And you're encouraging them, just go by the book and do it with a smile. It's like one of the best things you can do is hold your tenant to the lease, and this is for you and them,
right,
so that it's got a good outcome. So speak to that.
So I'll talk to something that probably most property owners, anybody who's around in the state of Texas last February has some kind of experience with the big freeze. Right? We don't get that cold in Texas, but February of last year, 2021, we had the big freeze. And one of the issues that was common to a lot of landlords was this busted pipe issue. And we had a few landlords who would come to us and say, Ernie, I'm trying to get in. I'm trying to be a good landlord. I'm trying to get things fixed. My tenant won't give me access to the property. And for each of these, I would point the landlord to the lease. Take a look at your lease. What does it say about access to the property? You don't need your tenant's permission in most cases. In most cases, especially on an emergency basis, you don't even need to give them notice that you're coming. You just come in and fix your property. But too many landlords don't know this. They don't know that they already have the right to enter, especially when it's about an emergency. Now, for a few of these, and you talk about specific cases, for a few of these, it was a matter of hostility where tenants would make threats and say, something to the effect of, if you come into my house, I've got a gun and I might just use it. You are not allowed into my house. Now, in Texas values privacy. Texas values the home, and Texas values the right of people to carry their a firearm, especially in their home. But Texas does not allow a tenant to unilaterally exclude a landlord. And so, especially in the event of an emergency, a landlord's allowed to come in. The problem that's caused here is the landlord must enter, if he or she is going to enter, peaceably, reasonably. And even if that peace is broken by the tenant, the landlord cannot at that time enter. And so you think, well, the homeowner has no rights. Well, that's not true. What's just happened is the tenant has violated their lease agreement and is now subject to eviction. And so they have every right to stand their ground, except when it means excluding the landlord from caring for their property and giving reasonable access. And so know what your lease says about you accessing the property and enforce your rights. If you have a stubborn tenant who will not let you in, again, bad sign. It's going to put your property at risk. And so you need to enforce your lease and possibly evict someone, even someone who pays rent, because they're not allowing you access to the property. Access to the property is a key and absolutely necessary enforcement, again, especially with an emergency repair.
The last question I have is what problem clauses in leases should we never have?
Well, these are the harder ones to pinpoint. I'll tell you the section in a lot of written leases that gets landlords into trouble is the special provision section, because it's blank.
Now, it's blank, and is it because they write it sloppily, or they put in things that can't be enforced, and then that draws other things under suspicion, like when judges look at things in court?
Both, yeah. It's a matter of you're not trained as as an attorney or a real estate agent with a license where you know where the limits are, and maybe this is your first lease. Maybe you've used the same lease with the same unenforceable clause, for years and years and years. For example, I have heard some landlords who come to me and say, "I don't need eviction help. I've got it in my special provisions. By signing this lease, you waive your right to an eviction trial, and you must give me possession immediately." Well, that's not enforceable. The Texas Property Code supersedes your lease, and it ensures that the only way you can get this tenant out is through the process of eviction. Oh, they tell me. Well, it's still there, and I'm just going to leave it there. Again, unenforceable provisions don't help you. In fact, they could hurt you. A court could sanction you for having a bad provision or attempting to enforce a bad provision. Also, in most written leases, there's a severability clause, which essentially says, by the way, if you have anything in this lease that's unenforceable, the court can just cut it out.